bellissimo, sono molto belli. Lo pubblichiamo. Perfetto, grazie Alfredo. Che pioggia. Guarda come piove.
So, good afternoon, buon pomeriggio a tutti, benvenuti a questa conference che si introduce dentro una scuola di alta formazione nell'ambito della giornata nazionale dell'alimentazione. E welcome everybody in this occasion of World Food Day. I would like to introduce the opening and the welcome addresses Professor Giampaolo Azzoni, Deputy Director of University of Pavia. Benvenuti di nuovo. Darà la parola di apertura di questa conference, di questo convegno, il professor Giampaolo Azzoni, prorettore di questa università.
Grazie, buongiorno e benvenuti a tutte e a tutti in quest'aula che si chiama Aula Foscoliana, dal nome del poeta Ugo Foscolo, che qua tenne una famosa lezione. Quest'aula foscoliana ospita i ritratti dell'imperatrice Maria Teresa, un po' che è coperto, e dell'imperatore suo figlio Giuseppe II. Due sovrani che diedero particolare attenzione all'Università di Pavia e proprio per la formazione dei giuristi. Quest'aula venne proprio voluta dall'imperatrice Maria Teresa, che ne diede incarico per realizzarlo allo stesso architetto della Scala di Milano, Giuseppe Piermarini, e si colloca questa sala tra le due parti dell'università, la parte legale e la parte medica, delle due grandi facoltà. Quello è il cortile medico e questo è il cortile legale. La formazione giuridica a Pavia infatti è antica e viene molto prima alla nascita dell'università. L'università nasce nel 1361, ma qua a Pavia, già nell'825, 825, e solo con 3 numeri, 825, non 1800, 825, il re d'Italia, Lotario I, poi anch'egli imperatore, fece un editto che stabilì qua a Pavia la prima scuola importante di diritto, 825. Nacque qui anche quello che venne chiamato l'Expositio ad Librum Papiensem, che è un famoso testo giuridico dell'XI secolo. Quindi benvenuti ai giuristi in questo luogo che da molti secoli parla di diritto, proprio in questi spazi. Benvenuti innanzitutto all'Advisory Council della CISG, e l'Advisory Council della Convenzione delle Nazioni Unite sui contratti di compravendita internazionale di merci, che in questi giorni ci onora del fatto che tenga qua i suoi lavori. Benvenuti ai presidenti dei 5 panel e ai relatori che provengono, almeno i relatori, io ho contato 8 paesi del mondo, perché abbiamo relatori dalla Spagna, abbiamo relatori dal Messico, dalla Svizzera, dalla Francia, dal Brasile, dal Giappone è facile da identificare, from Japan, ecco, dall'Olanda e dall'Australia. Benvenuti a tutti loro, a tutti i giuristi anche di altri paesi, anche agli italiani, eventualmente anche agli avvocati che fossero qui presenti. Bene, al centro di queste giornate vi è appunto la Convenzione delle Nazioni Unite sui contratti di compravendita internazionali di merci, CISG, che ho letto per sapere qualcosa, sono stato colpito dalla qualità del testo. Legal drafting fatto molto bene, un testo scritto veramente bene, come capita difficilmente, quindi bravi voi che la interpretate, perché è un testo che mi ha colpito per la qualità della scrittura. E benvenuti ovviamente a tutti voi che vi occupate di questa convenzione. Ecco, questa conference è dedicata al tema della CISG nei rapporti con la sostenibilità e col diritto alimentare, food law, a testimoniare che la Convenzione è un organismo vivente, vive la Convenzione, vive attraverso anche nuovi temi. Non si pensava alla sostenibilità quando si è scritta la Convenzione dell'80, è un tema che è venuto molto più tardi. Eppure si può leggere la Convenzione alla luce dei temi della sostenibilità. Tra l'altro sono molto lieto che nell'ultima giornata si presenterà anche la traduzione autorizzata in italiano della guida tripartita Legal Guide to New Firm Instruments in the Area of the International Commercial Contracts with a focus on sales, che tra l'altro è stata curata proprio dal professor Ferrante. Quindi grazie a tutti voi, benvenuti, e un grazie particolare, l'ho appena citato, al professor Ferrante, che è l'organizzatore appassionato e capace di questo incontro, perché io credo che questi incontri siano proprio dei lavori di tessitura, e il telaio lo conduce questo il professor Ferrante. Quindi grazie veramente a lui per questo ottimo lavoro che rende qua la vostra presenza a Pavia. Grazie anche alle sue più dirette collaboratrici, e voglio ringraziare la dottoressa Capuano e la dottoressa Colombo per il loro grande lavoro. Benvenuti a tutti a voi, buona permanenza a Pavia e buon futuro a questa bella e importante convenzione.
Grazie Prorettore. Really thanks, Deputy Director. Ora passo la parola al direttore del Dipartimento di Giurisprudenza, il professore Michele Madonna. Now the floor is for the Director of the Department of Law of this University. The floor is yours.
Grazie.
Professor Madonna.
Grazie e un caro saluto, un benvenuto a tutti da parte mia e sono molto lieto di portare il saluto del Dipartimento di Giurisprudenza agli organizzatori e ai relatori. Mi associo ai saluti e ringraziamenti del professor Azzoni di questo convegno davvero importante, di questi giorni così importanti che onorano il nostro Ateneo e il nostro Dipartimento. Vi saluto e li ringrazio. E ringrazio veramente di cuore, sicuro che le mie non sono parole di circostanza, il professor Azzoni lo ha chiamato tessitore, io lo definisco motore, il vero e proprio motore di questa iniziativa, il caro collega e amico, il professor Alfredo Ferrante. Voglio complimentarmi con lui non solo per la giornata odierna, per queste giornate, ma per il dinamismo e la generosità con i quali si è fatto promotore in questi ultimi anni a Pavia di tante iniziative culturali, di tanti progetti di ricerca di rilievo internazionale e di molti importanti progetti in diversi ambiti. Questo si colloca certamente, è stato già ricordato dal professor Azzoni, in una tradizione dell'Università di Pavia e anche tempi più recenti della nostra facoltà, del nostro dipartimento, che hanno avuto sempre e ancora oggi hanno una forte vocazione internazionale. Basti solo pensare al contributo rilevante della nostra scuola di diritto internazionale con il caro compianto professor Franco Mosconi, Cristina Campiglio che mi ha preceduto nel ruolo di direttore del Dipartimento, Giulia Rossolillo che anche dà un contributo a questa iniziativa e anche agli studi di diritto comparato con il compianto professor Gabriele Crespi Reghizzi e la professoressa Alba Negri. Alfredo Ferrante si è inserito pienamente in questo solco con il suo impegno generoso nella pratica di quella che Paolo VI chiamava la carità intellettuale, che è anch'essa una forma di carità, di servizio al prossimo. Questo tema della carità intellettuale è stato al centro di un recente forum internazionale del Gran Sasso a Teramo, a cui ho avuto la fortuna di partecipare e che tra l'altro vedeva tra i promotori Unidroit, che è anche tra i promotori di questa iniziativa. Questo concetto di carità intellettuale è stato ripreso anche da Papa Francesco in tempi più recenti. Il Papa ha sottolineato la responsabilità storica di chi opera nei diversi campi del sapere per superare la tentazione di isolarsi in sfere particolari e promuovere una nuova cultura della conoscenza e divenire veri e propri discepoli della conoscenza, così li chiama il Papa, che contribuiscano all'incremento di una solida cultura per le giovani generazioni. Certamente il convegno di oggi rappresenta, a mio avviso, un ottimo esempio di carità intellettuale, sia per le prestigiose istituzioni, state già ricordate dal professor Azzoni, che hanno contribuito a promuoverlo, ma anche e soprattutto per la scelta del tema trattato, la sostenibilità e il diritto alimentare proprio nella giornata mondiale dell'alimentazione. Si tratta di un tema cruciale e decisivo, non certo solo per i giuristi, ma per l'intera società e credo per l'intera umanità. Qui la carità intellettuale si incontra con la carità sociale, con la carità politica e con la carità tout court. Su questa virtù ha scritto delle pagine molto belle il nostro prorettore Giampaolo Azzoni, ed è questo un altro importante motivo per cui dobbiamo essere molto grati a chi ha promosso questa iniziativa e a chi darà il suo contributo nell'odierno convegno. Grazie e buon lavoro.
Buon pomeriggio nuovamente. Mi tocca dire 2 parole, ne dirò solo 2, non vi preoccupate, solo per ringraziare. Lo farò in inglese per il rispetto della cortesia che l'Advisory Council ha tenuto per riunirsi qua tutta questa settimana. So, welcome again. I just would like to tell you some few words about today, this week, and the aims and the scopes of this conference. Well, first of all, thanks. Thanks all. Thanks to the University of Pavia, to Deputy Rector, Professor Azzoni, to Professor Michele Madonna and the new Director of the Department of Law. Thanks of all the administrative staff, Francesca Capuano, Michela Colombo, the technicians, Enrico Giorio, the PhD student that they are here working here, Leila Diaz, Ezequiel Mendieta, and all the other one that give some little stone of this project. So thanks for the other and on for my job because it's my work, so this one. Thanks for Advisory Council that decide to make his meeting here. So long time ago, there was a meeting in Italy, in Rome, but this is the first time that in an Italian university we have the meeting of the Advisory Council. And God wanted that this Monday an opinion of the Advisory Council will approve it. And will approve it just the number 1. So maybe we'll start again for year to make my job, I mean, making comparative law and with an international perspective. Okay, this is a good day because it's an occasion of the World Food Day, but I would like to tell a thing that is my birthday. My birthday with this university. Exactly 4 years ago, I will start, the 16th of October of 2020, I will start with to become a professor in this university. So the date is important, and I'm so happy that this happened. 16 but of December of 533 was promulgated the gesto as well. So it's a part of the history. And this is the aim of this conference, make history. We already make history, having the reunion of the Council Advisor in the first university in Italy. We have made history with the legal opinion revised number 1 of electric communication, and they think that we are making history with a new path in comparative and international law. There is lots of publication and investigation on food law. There is some investigation of CISG and international contract, but I think it's the first time that we make together this one. And as Professor Albisesi told with me in a couple of occasions, the new path is not only food, but agri-food, but Professor Albisini tell maybe later. So, old history, but a new paradigm. This is the new paradigm. I hope so, and I'm sure that with this conference will start a new path in CIG point of view and relationship with the agri-food. A new path under the academicians and under business. So this is this one of another aims and scope of the conference. And the last but not least is just that everybody come back home today or when we'll finish and remember Pavia in their art or in his her art. This is the idea. That for Italian, well, it's easier, but I would like that every foreign academician here come back and hope to come back again as soon as possible in Pavia and making bridge with our university, not only in law, but with all the other faculty. I mean, that Pavia in your art and your brain mean happiness, seriousness, and trustworthy making manner of making job with the smiling but working seriously. Really, thanks. E ora passiamo al prossimo pannello. Pregherei il prorettore vicario e il direttore che faccia una foto e poi cediamo il passaggio, così permettiamo di cambiare le cose logistiche.
So, good evening, everybody. I must thank personally and with enthusiasm to this invitation, to this occasion, to meet foreign colleagues from many other different areas of studies. And this is significant even regarding what will be the future of what we are going to do next years, or legislators or judges or practitioners are going to do. And I'm very grateful to Professor Ferrante, who invited me, and to the University of Pavia. I must say that I'm also, how to say, really pleased, because it is the second time this year that I came in Pavia, and there is a great interest toward these topics in Pavia. We had a meeting with Professoressa Carola Ricci some months ago with reference to the new rules regarding wine. But what is interesting, in fact, is that there is a growing interest in many areas of studies regarding these topics, which traditionally have been, how to say, closed in a very restricted place. And there are some magic words in the title of this conference. Sustainability. What is sustainability? Until a few years ago, nobody heard about these terms. And nowadays, we have in many official documents, we have in regulations, we have also, in some way, within the new text of our Constitution, the new Article 9, which is speaking about environment and biodiversity. And what is the relation between sustainability and contracts? And another point, more easy to understand, the relation between sustainability and agri-food law, as we told a few minutes ago with Professor Ferrante, because, of course, we have been, how to say, accustomed to distinguish food law and agricultural law. And agricultural law in the 70s, still in the 80s, in Italy, was a matter for all the lawyers discussing about property, borders, rights, that's all. And there's been a famous scholar who wrote about agricultural law closed within the borders of the land, and not. Today is not so. Today, sustainability, in fact, links to another magic word which is emerging. Maybe we can close the door. What do you think? The final door? Otherwise, we will participate to all the holiday of our students. But in any case, the other word that we are, in many cases, using or listening today is the word sovereignty. And, you know, we had an idea of sovereignty which was linked to sovereignism. It was linked to an idea of a sort of state. But when we are speaking about sovereignty regarding food and agriculture, we are just speaking of something completely different, in another declination. I don't want to take too much time. I promised it to Professor Ferrante, otherwise I will be subject to very, very cruel sanctions. But we cannot forget that movement in South America starting to speak about sovereignty as a right of people. And even the declaration of FAO in 1996 in Rome spoke about that. And so in this scenario, what happens? That sources of law and even the relation between what we consider law and contracts is just totally changing. So what we have today is that agri-food law is no more something closed in the borders, but is a sort of open laboratory. And I use this word not by chance. It's just open because we have many unconventional ways to do law. National, but even regional, local, international levels intersect. And more important, for a private lawyer, as I was in my past, even the borders between public and private law are even less and less clear today. And you know, even the problem of the jurisdiction is not clear. I had some cases as a lawyer in which I was discussing on conflict among actors of the agri-food chain, but in fact we were not discussing before the civil court, but before the administrative court, because in fact what was in joke was the application of administrative rules. On the other side, always speaking of this laboratory, we have a dating tradition of comparative studies. I am really, really pleased to have the opportunity to meet many colleagues from different countries working on this topic today. But I must also remember that there was a scholar who already in the 60s of the past century, a US scholar, you know, we always think that US scholars are traditional, but no, it's not always so true. And he wrote in 1967 a book on principles and objectives of a comparative food law. So already in the 60s, where nobody of us was thinking to that. But on the other side, I must say, I was just speaking with a colleague some minutes before, that in Tuscany, in the 18th and 17th century, there was a great interest towards rules coming on agriculture from France. And in Florence has been created in 1957 the new Institute for Comparative Agricultural Law, which is really incredible if you think to the Italy of the 1957. And third of all, and I'm just going to the end of this, I will leave later on a long paper. But what is really interesting is that we have been faced to, to play with this phenomenon by what happened before the end of the century and the new century in the area of food law. And if you look to Regulation 178 of 2002, which is the fundamental regulation on food safety, what you will discover, which is very interesting, that there is a multiple legal basis. This regulation has been adopted regarding agricultural policy, regarding market, regarding health protection. So all the topics that I imagine we are going to discussing today have been part of this. And on the other side, there is an increasing role played by what usually called, how to say, international rules. But what we mean with international rule? I'm not an international lawyer, so I hope to be considered not too guilty for the things that I'm going to tell. But what about resolutions adopted by the Codex Alimentarius Commission? What about resolutions adopted by UNECE? Are they applicable before our courts or not? And you know, there has been, for example, just to give you, how to say, an effective situation, in 2012, a proposal of a new regulation by the European Commission introducing the principle that products which were respectful of recommendations of the Codex Alimentarius Commissions had as such to be considered admitted in the European Union. The European Parliament refused to accept this proposal of the Commission. This is very unusual because usually all the proposals are accepted. And it has been introduced only that in adopting new text, the Commission must take into account what was adopted by this organization. So even this is the second point, really, really significant. What is going on? And finally, contracts. Some colleague wrote in these years interesting research book on the so-called hybridization of food governance. What's the meaning? They were intending that sources of law are always more complex and that sources of private origin, of apparently contractual origin, in fact, are regulating the day-to-day decisions. And in fact, they were thinking, of course, to the role of the great buyers, the great international buyers, the great companies that were introducing specific rules in their contract. And if you do not respect that contract, you will be forced outside of the market. On the other side, we have some significant reactions, and really I'm going to the end, reactions in the European Union with the new directive of 2019 regarding unfair commercial practices in the agriculture and food area. Look, originally the proposal of the Commission was only unfair trading practices in the food area. It has been expanded by the European Parliament to include the agriculture area. But what is more important is the transnational dimension that this directive assumes, because it applies to all contracts stipulated even with buyers located, for example, in Switzerland, outside the European Union, because it is not by chance that many big companies have their legal headquarters outside the European Union. And the difficult problem is, and I am curious to listen to the speeches of the colleagues to know what can be the solutions. What about acting before which court for what happens with a contractor who is not in Europe? And last, we are seeing every day a lot of examples of this, how to say, the comparatists spoke about legal transplants. There was a lot, I don't want to take time on this, that was a very, very interesting point. But we have, in fact, from one side, legal transplants. We have European models, like the model of IGs, which have been adopted in many other systems, completely different. I was speaking with a colleague about Australia a few minutes ago, or even in China and so on. But in another case, we have also transplant in Europe of rules coming from outside, and to know what happens. And I just want to close this introduction, I hope to be enough short, two very recent regulations regarding sustainability adopted by the European Union. The one is the regulation regarding the use of nicotinoids against some insects to protect plants. Those nicotinoids have been allowed in the past because they are not, totally not dangerous for human health. And they do not leave any part on apple, fruit, vegetables, and so on. But recent studies demonstrated that they are of noise for bees and other pollinators. So the European Commission adopted a new regulation, a delegated regulation, which will come in force next year, stating that these nicotinoids cannot be used in Europe, and this is clear, is easy, but cannot be used even for the production of vegetables in countries outside of Europe. The question for colleagues who practice is that there is nothing on the single fruit coming at the borders. We cannot discover whether or not have been used if we look to the apple, to the strawberry, or whatever. So how can we be sure of that? We can be sure only if the other countries, China, Uzbekistan, Peru, adopted national rules giving the security that that sort of nicotinoids have not been used. So European rules are having effect outside other countries. And the trouble is, what are the tools of justice in those cases? Which is the court will be competent. And the last one, there has been a lot of discussion, even on newspapers in this period, in another regulation adopted by European Union, against deforestation, against land which has been cut in the Foresta Amazonica or wherever and wherever, and who wants to import in Europe a long list of products from maize to potatoes to meat to animals and so on, must demonstrate they did not use land coming from deforestation. There has been a lot of political discussion on this. This regulation should enter in force next January. In fact, it's been postponed of 1 year because, of course, there is the other part, and this is really the conclusion, the other part of sustainability. Certainly, environmental sustainability. But what about social and economic sustainability? Among the goals declared in the Treaty of European Union with reference to the Common Agricultural Policy is to give adequate income to farmers. What is the situation of farmers outside Europe? Is Europe, how to say, entitled to decide what farmers can do in South America? I will ask for an answer. I thank you for your patience, and now we can start the session, and I will ask Professor Pilar Pelares Vizcasillas, and she is going to speak about contract clauses and supply chain in food system, and just a point is that. Grazie.
Good afternoon. Thank you very much for the introduction to the topic, Professor Albasini. It's really a pleasure to have you as a moderator of this panel, considering that you are really an expert in this area. And therefore, I'm sure we will learn a lot from you. Let me, first of all, thank you, the University of Pavia, and especially Professor Alfredo Ferrante, for the kind invitation for the CISG Council to be having its meet here in Pavia. I'm currently the chair of the advisory council, and I'm sure I'm speaking on behalf of the whole council to thank the warm and wonderful stay that we're now having here in Pavia, in the university, in the colleges, just inspiring and transpiring the culture, all the ancient of magnificence of the buildings in the university. It's really impressive. I have to say that Pavia is going to be in our hearts forever, not only for the wonderful state that we are having now, but also because, as Alfredo was mentioning, we have our first opinion revised here in Pavia, and therefore it will be Pavia always attached to our council and to our hearts. I have a presentation. I don't know whether it's ready. Yeah, I see it's over there, so thank you. Professor Albasini was making a lot of questions that I'm not able to answer, so I have to say, first of all, this is a very big topic, very important one, with keywords, as mentioned before, CISG, sustainability, agri-food law or food law. And therefore, it's really difficult to go to catalog the problems that can arise in this area. So therefore, what I'm going to do is to have a more general approach, and then my colleagues, Professor Spencer and Professor Munoz, will tackle more specific problems within the CISG scope of application and the CISG interplay with agri-food or food systems. Let me begin with some words that I like very much from the one very important case in the area of climate strategic litigation, which is the case Juliana versus the United States. And this is the dissenting, one of the passages of the dissenting vote of Judge Stanton. When the seas envelop our coastal cities, I have not my glasses, but okay, I will try. Fires and droughts haunt our interiors, and storms rage everything between. Those remaining will ask, why did so many do so little? And this actually encompasses the real problem, the dramatic problem that we are encountering today with climate change, which of course is a phenomenon within this sustainability problems that are very much encountered in the agri-food system. Indeed, we are approaching to a point of no return in relation with the problem that we're experiencing with climate change, but still we are in time to act. And that's why we are having the European Union leading as an ambassador of the climate emergency, not only in Europe, but trying to also to influence around the globe about this global problem. That's why the European Union is so active in terms of climate change in relation also in general to sustainability, but precisely lately in the focusing on climate change. As you know, the CISG, the environmental, social, and governance are the acronym for these sustainability aspects, and I think they are much interrelated, because when we speak about environmental, we also have to speak about governance. Those are very much interlinked, although sometimes it's not well aware of, people are not well aware of it. Of course, we're within the phenomenon of the Agenda 2030, the Paris Agreement, as you know, or the UN Climate Convention. But so meaning the globality of the problem that we are encountering here. Let's take a look. For example, this is the data coming from agroinsurance in Spain. And you see here the data of the accidents in the area, meaning climate accidents, in the area of agriculture. As you see, from 2012 to 2023, there has been a double in the data of the phenomenon of the accidents, of the impact, of the economic impact because of climate change. This means that the climate change is impacting very severely in the agri-food system, indeed, and it's also causing the increase, for example, in the insurance premiums, that they have also triplicated because of the effect of climate change. Yes, they are referring to Spain, indeed. Yes. So we see also what the importance of the agri-food sector in the world and within the European Union. You can go through all the data and see the importance of this agri-food system in the economy and also within the European Union. That is why also the European Union is considering the agriculture sector as one of the most important sectors to be dealing with European Union regulation in relation with sustainability. It's not only that climate change impact the agriculture system, but it's also how agriculture system impact the environment. And you see over there in the last 2 points some data that are also in that also shows the impact of the agriculture system in the environmental aspect. Sorry, I'm going to take my glasses. So I'm struggling to see a little bit here. Okay. So, well, you see here, as I said, this impact. So that's why as I was mentioning, the European Union is focusing on the strategy Farm to Work, which encompasses globally many areas related with the agri-food system. Take a look to objectives 6 and 7, which are probably the ones more related with the area that we're talking here. The sustainable value creation in the European food supply chain through partnerships and sustainable sourcing in food supply chains. That's why we can talk about a sustainable agriculture system or sustainable contract system within the agriculture industry. As you see, is one of the key industrial ecosystems in identifying the European Union industrial strategy, which is a global one and focusing especially on the agri-food ecosystem. And that's why the European Union is dealing towards this area very heavily. Of course, these agri-food ecosystems. You have here a definition found in one of the European Union documents. I'm not going to bore you a lot with the amount of documents that the European Union is dealing in this area, but still they are, indeed the European Union is focusing on a sustainable supply chain in the agri-food system. And this, of course, leads to the connections with contract, but not only with contract, we will see in a bit, also with corporate law, because I think that's an area, both of areas that need to be certainly connected here. Of course, since we are talking about contracts and in a very much international, globalized, and interdependency of the contracts in the supply chain in the agri-food system, that's why CISG comes certainly into play. I will not go into much of the details because my colleagues will be doing so, not only today, but also tomorrow. But certainly there is no problem in considering the CISG application alongside the agri-food supply chain. And usually, and I've been analyzing a little bit how the supply chains works here, and I will show you later, there's no problems towards the application of the CISG. And also the CISG is such a flexible instrument that is able to encompass many of the kind of situations that you will find in the supply chain in the area. It is true, though, that when we're talking about supply chain, and especially supply chain in this agri-food system, also you have to take into account the future of long-term relationship. That is important to keep in mind because sometimes there will be the need to adjust some of the CS rule in order to encompass better this future of the long-term relationship as opposed to the one-shot contract that probably was in mind with the drafting of the CISG. Also, very impacted in this area of international commercial contract is the recent due diligence directive, as you know, very recently approved by the European Union, but that of course makes also some kind of interplay with the CISG, but I have not time to go into this. Certainly when we go into the agro-systems chain, we have to think that the value chain is different depending on the sector. So that's why it's very important to focus on the specialties that we find in the agri-systems chain, which, as you see here, we have, like in the streams, we have millions of players, both in the consumer side and the farmers. That would be millions of players in those chains. And in the middle, more small chains in the business of the distribution or the retail system of the food chain. So keep in mind this in order to encompass the problems that we might encounter contractually speaking in the agro-systems chain. I have just taken here the chain of supply as Nestlé, who is the bigger producer in the retail system, in the agri-system, how they describe themselves, their own supply chain. So that is it's very interesting to see how they describe the full range of the supply chain, and it goes from one end to the other, one spectrum, since you have the products from the land till the end of the life cycle of it, and all the middle areas. So I was telling you that indeed sustainability is one of the modern, maybe not so modern, but at least one of the modern topics that we see all over in the press and in legal aspect. And it is also interesting to see the gradual process towards sustainability. Here, what I want to focus, because I don't have the time to go into all the details, is that we are coming from the so-called social corporate responsibility. That was the origin of the phenomena. This was a voluntarily processed within the companies, but now, because of the action of the European Union, we are going into a more imposed duty upon enterprises and upon businesses in order to have sustainability goals included within the business strategy, in business models, business risks, so on and so forth. And so this means that big efforts have to be made by businesses in order to encompass the new features of sustainability. That is impacting a lot SMEs, as medium and small enterprises, but okay, that's something I cannot have the time to go into. And we found also the new paradigms, how sustainability is impacting in corporate governance, in how the businesses are including sustainability aspect throughout the whole organization, that is vertical and horizontal in the whole organization, and how the corporate duties that have been born because of the European Union regulation, meaning the duty of transparency, the duty to give information on sustainability aspects, those were the origin of the more obligational aspect that we find within the contract. It's because we find first in the area of corporate law on the duty to inform and the duty of transparency, how these duties have been transferred or transplanted into contracts. For this, I have to say it is very important to take into account that the sources that later on we can find in contract law, in the supply chains especially, comes from either the policies within the companies, the ethical or corporate codes that we find also within the companies, and even the public commitments, which are important sources of obligation of companies. Also, the idea of transforming or, let's say, creating this sustainability as a risk, as a non-financial risk within the business, that is something that has impacted and developed this area also within contract law. And of course, within contract itself, we have the new paradigms as well. Now we find the idea of drafting ESG clauses, and I have to say that there's not a single model of ESG clauses. Edgardo will be referring here a little bit more about this, but different models of ESG clauses that we might find depending on the structure of the supply chain, depending on how this contractual relationship is established. And in this regard, this is also an interconnection here with the remedial system, ex-ante, developing of ex-ante remedial system, as well as the development of ex-post remedial system within contract chains. This means, for example, the idea of companies to have a preventive plan before the risk is born, in order to assure that those risks, once they arise, are well taken care of by the company, as well as the post-remedy, how to tackle the risk when it has been born. This, of course, has to do with the due diligence that actually the directive wants to cover within states. And of course, also the relationship with contracts and the litigation system. That is also something important to keep in mind in this area, because we're finding an increased litigation in the area, especially of the supply chain, and we're seeing some cases now precisely in the area of deforestation that our chair was talking about. What are those new paradigms? I think we see the globality of the problem. We see an intersection, an interplay very important between private law, human and environmental law. Therefore, we see the importance of considering private law aspect with also public law aspects as well. And this means to take into consideration, when we are considering supply chains in a pure commercial kind of contract, also public law interests. I just invite you here to take a look to the annex of the Directive of Due Diligence, where you find how all these international treaties related to environmental laws, labor laws, social aspects are incorporated in the idea of the due diligence of the companies, and the tools for the due diligence directive is precisely the contract. So we see here also the importance of contract law and how these mass of rules also interplay. Precisely the importance of soft law, I think that is also something that we have to take into account when we discuss hard law, CISG, and the mixture or the mixing with soft law instruments, because they are really important in this area. And we have specific soft law instruments in the area of the agri-food system. You find here some of the general ones, but also the particular ones. I cannot go through all of them, but the particular ones in the area of the agri-food system. New paradigms that I think we can open for a debate, and I'm finishing very quickly, whether climate standards or sustainability standards are considered part of the European public order, with all the consequences that arise from this assertion, from this sentence, in relation both to commercial contracts, but also in relation to arbitration as the usual or one of the usual methods of solving disputes in the area. Are we in front of a new lex mercatoria climatica? That is a question that I have posed to myself. I think that raises, again, very interesting theoretical and dogmatic, also practical questions, and of course, very much related with Article 8 and 9 of the Convention. Does this mean that we have, or that we get reach to the level of the implied sustainable clauses within the contract or even within the CISG? That is something that probably my colleagues will be dealing also with. Also, lessons to be learned in this area is the importance of climate science. That is something that we will see, that we are seeing now in contract law, in the area of contract law, and when, in order to qualify suppliers, in order to impose standards within the ESG clauses, in order to determine the breach of the contract, but also in arbitration, where we will have the need to tackle with all these climate science aspects. And I'm finishing here the same way that I start, with another quote from Judge Staton in this dissenting opinion in the important case that I mentioned. Most describe any relief we can offer as a drop in the ocean. These final drops matter a lot. And precisely this conference matters a lot for the future in order to build a more sustainable agri-food system. And so I'm very grateful and thankful for our organizer, Professor Ferrante, for this. Thank you very much.
I think that we are all really grateful to the colleague for this exposition and for all the, how to say, questions, doubts, uncertainties that she gave to us regarding what is the content of the clauses. I just have taken something, but a new lex mercatoria. We spoke a lot about lex mercatoria in Italy with reference to other points, but what about the lex mercatoria climatica? Or implied environmental clauses within the contract? And what about the role of the judges? Are the judges, how to say, supposed to give relevance when interpreting contracts even to these implied clauses or to the direction you just insisted on, the intersection, a possible intersection between private law and human and environmental law. But the 2 points, human and environmental, we have seen, you just mentioned the forestry regulation, not always are coincident, and we must in some way establish a line of values to the judge. So thank you very much. We will read with great pleasure. And now I would ask to Professor Edgardo Munoz Lopez of the Universidad Panamericana di Guadalajara, Mexico, to speak on sustainable supply chains, integrating CISG standards in CISG food and aliments contracts. We go back to the contracts.
Thank you very much, Professor Albicini. It's a great pleasure to be here. It feels like a bit of pressure to be standing here in so reputed and historic university where so many great jurists and others scientific thought and research. But it's indeed something that I appreciate, and I want to thank Professor Ferrante and the authorities of this university for giving me this opportunity. So I come from Mexico, and I was hoping to bring some sun with me. Probably he lost his luggage in Milan, and he decided to wait for it. But I have a presentation. I don't know if it is available. And I want to start by asking you to look at this picture. We have there a basket full of vegetables and fruit. And we can imagine that in that fruit, although I don't see it, there is a pineapple. And many people in Italy can eat pineapples. And the fact that you can eat pineapples or papaya or any exotic from the European perspective food is thanks to the fact of international trade. One of the elements that allows to have this tropical fruit in Europe is that tariffs on goods have been lowered to 0 in some cases. Also changes in means of communications, obviously. Also reduction of import requirements, phytosanitary rules, and probably also because of the sales convention on the international sale of goods. There is no dispute that all these food and commodities are governed by the convention. But when the convention was drafted, actually, and you order as a buyer a pineapple, it only matters that it looks like a pineapple and that it tastes like a pineapple, right? Buyers didn't actually worry about the process of planting, growing, and harvesting that pineapple. And the same would be applied for products more elaborated, like a yogurt or any other food that you may imagine, like cakes. What matters is that they look like that and they taste like that. But people have changed their view about what they buy, especially in food, but also in other products. They want the process of planting, the process of growing and harvesting to be sustainable. They expect companies that these things that they are eating are environmentally friendly, that they are sustainable, and that they comply with minimal requirements of good governance. In other words, that they are not the product of corruption in any of there is no corruption in any of the process. And this is what we call ESG issues or rules on food, right? And I think probably what changed the view of what we eat is the fact that we came to realize that there is a big economic impact in the way we produce food. And also that in some occasions, it was not even healthy for human consumption. And this is probably due to new generations' expectations that what they will eat, at least, is not something that has collateral bad effects. And so, in my presentation, I'm going to talk about the issues, in other words, yes. I'm going to talk about how enterprises try to comply with these new expectations and where do they come from. Obviously, there is a change in mentality in social values that have been reflected now in some laws, in some legal regulations. And I'm going to talk about how parties distributed between themselves the risk of having products that do not comply with these new standards called ESG standards. Okay? So probably the legal basis of this is all these public law instruments that have been enacted since many time ago. If you look at the third column, there you have all these United Nations conventions and labor organizations conventions and OECD guidelines on how to act as an enterprise. You also have in the first two columns what is called the UN Global Compact. These are ethical principles that are embodied, that are adhered to by enterprises, that basically reflect the commitment that they will not do business infringing basic human rights that are reflected in treaties, that they will protect the environment while they do business, and obviously this applies to food companies, that they also do not practice corruption. Because, as you may know, also in the past, and probably today, I'm going back a bit, the fact that we still have some food products that are not environmentally friendly, grown and harvested, or that they are the result of corruption or violations of human rights, is that law is not regular. In Europe, in the United States, in many developed countries, there is strict rules on how to efficiently and sustainably produce food. But in other countries, this is not the case. Sometimes they have regulations, but they have a very weak rule of law that at the end of the day means that these regulations are not enforced, are not implemented. And these big companies from developed countries sometimes take advantage of this, of the fact that there are so-called unsustainable heavens somewhere else, where they can go and produce at a low standard, or in any event, they can hire someone to do the bad jobs for them, right? But as I said, things have been changing. Because now, if you look at the column, at the last column where there is yellow, we have some laws that have started to make companies located in Europe, in US, and in UK, and in many developed countries, responsible for what their suppliers do somewhere else. So it doesn't matter that these big companies comply with the law in their home jurisdictions, they are also liable for what others do for them. And even if they are not bound by law, these big companies have started to worry because of the possible boycotts that may result from taking advantage of these unsustainable paradises, right? So what do? Well, what companies have done to tackle this issue that may affect them legally or commercially, they have started implemented what is called codes of conduct or codes of ethics. And these code of ethics are like standard terms that they try to incorporate into any relationship they have with suppliers overseas. And I have here, if you have a look, Tyson is one of the biggest food companies, food providers in the world, with a figure of, I think, I read over $53 billion only in 22. So it's a very big company, and in the square, in the red square, you see that, for example, in this supplier code of conduct, this is something that its suppliers should adhere. They bound them to respect many of the international conventions regarding protection of human rights, environment, and anti-corruption. So these international treaties that normally apply between countries have been, in a way, incorporated into legal relations so that these big companies can at least have some security or make sure that they are not buying something that is infringing basic ESG standards. have a look at this. This is Nestlé. Professor Perales has already made reference to this Swiss big company. This is the code of conduct of Nestlé, and they acknowledge that they have around the world over 165,000 direct suppliers and even more sub-suppliers, right? So with this code of conduct, they as well intend to have some sort of harmonization in the production processes of all their suppliers. Walmart, which is not Nestlé, which is in the retailer business, but is as big as relevant, also has his own integrity code of conduct, also acknowledging that they have over 10,000 suppliers. And with this code of conduct, we will have a look at more specific what the obligations look like. But they also expect that with this code of conduct that apply to their suppliers, they will avoid any infringement of ESG. Now, the question is, what does the sales convention, which governs international sale of goods, has to do with them, or how they interact? Well, this code of conducts can only be binding on a supplier if they are incorporated in the international sales contract. And obviously, the CISG is designed to facilitate incorporation, or at least settles the requirement for that incorporation. The CISG follows the notion of offer and acceptance to have a contract. Everyone here, we know about this because we make deals every day. Well, it's the same mechanism that is taken by the convention to form a contract. But at the end of the day, what counts is the intention of the parties, right? And this is relevant. This has most relevant because depending on what the parties agree about the goods is the standard to consider whether the seller complies with the convention and the contract, whether the seller deliver conforming goods, right? This is the relevance of this, the incorporation of this code of conducts. But these code of conducts are not the specific offer and acceptance, we all know. These code of conducts are like even books, complete books, that the parties do not actually, in a way, copy and paste in the offer and in the acceptance. They usually refer to them in a way. And the convention and case law has developed in a way to tell us when a correct or binding incorporation of this code of conduct happen. And we have several cases. These cases say, well, so long as the offer refers to them in the front page of the offer, even with a link to a web page, that would be a proper incorporation of the code of conduct into the international contract. They also tell us, this case law, that they have to be easily accessed. You cannot expect the buyer, for example, the supplier to go and search the complete web page of the buyer to see if there is the code of conduct referring the offer. They also said that it should be in the language of the contract or in a language that is reasonable to expect that the parties would understand, right? Especially the party that is bound. So we have quite some case law about how this code of conduct can be incorporated as a standard terms in a contract. What is more problematic is when you have a big seller, a big supplier that has his own code of conduct that applies to his own sales. That would mean, I think it's called, is the supply chain, but upstream. And when you have a buyer that has his own code of conduct that is for his suppliers downstream. And what happened is that sometimes you have code of conducts. For example, look at this one. You have Tyson as well, and this is his standard terms that incorporate some rules on conduct as well. And you have Unilever on the other side, which is this big food company as well, I think from France. And if we have a look at their own terms of conditions, on the one side you have, I think it's too small to see, but on the one side, Tyson's terms and conditions said, well, any other terms and conditions from the buyer do not apply. But on the other hand, you have the buyer's terms and conditions that say, or state, acceptance with this code of conduct supersedes previous code of conduct submitted by the seller. So you have a battle of code of conducts there, or a battle at least of standard terms, and the CISG has been also developed through case law to take a position on which of the two code of conducts or standard terms would prevail. And the position is, probably the majority rule is the so-called knockout rule. If you have standard terms or ethical code of conducts that contradict each other, those contradicting provisions will eliminate, and only the not conflicting terms of those code of conduct will survive. The rest will be supplemented by the convention. Good. And also the CISG will allow, for example, that different industry code of conducts or its provisions are incorporated into the contract. And we have a clear example here. I think it was already mentioned by one of my colleagues. This is the EU Code of Conduct on Responsible Food Businesses. And according to this news, there is at least, it says 60, in 2000, I don't know, the news is from 2001, there were already 65 big producers that have adopted this code of conduct. And as they are members of this food code of conduct, it is probably possible that all the terms of the code of conduct can be interpreted as usages in that industry that incorporate obligations into their international sales contract. And I have a second part, but I think I'm going to do this very quickly. I just need to say that in those code of conducts, you find typically two types of obligations, and in many contracts, you have obligations of result, where the supplier is bound, agrees to deliver the goods that comply with the ESG process of planting, growing, and harvesting. And you have a different type of obligation, which is an obligation of best efforts, where the supplier does not guarantee that the goods will be sustainable, will not be sustainable or untainted, where they say we will only do our best effort to follow the procedure, the protocols, so that we can get a sustainable food product. And you can well imagine that sellers, what they want is to incorporate into the contract best efforts obligations, because they may have their own suppliers that they cannot monitor. But buyers, especially buyers in big economies, they would like to have in their contract obligations of results, where the supplier warranties and is strictly liable for compliance with ESG obligations. And basically, the next slide talks about how to identify obligations of results, obligations of best effort. We have case law telling us, again, how they look the obligations of best efforts, how those of results says. I have here a square that will compare in two different code of conducts how these obligations, the same obligations, may be only an obligations of best effort or result. And here I have an example as well Again, this is HEB. I don't know if you know it, but it's a very big supermarket in Texas. They are quite big, and they are in Mexico as well, in the north of Mexico. And if you see suppliers' food products, this is their code of conduct. They have obligations of results for all of them. They expect that the food they deliver to them are ESG compliant, they sustainable. But curiously, we have a same provision in the same suppliers code of conduct where vendors are only expected to use reasonable efforts to promote among their own suppliers these obligations of sustainability. So it's all about, actually, I would resume this, it's all about managing or allocating risk between companies today about, or with regard to whether the supplier should be strictly liable, and this is something Professor Spencer is going to talk about, or whether it only has an obligations of best efforts. And I would like to finish here, thanking you for all your attention, and yes.
Grazie molte. Thank you very much, Professor. And because in fact, what was clear listening to your presentation is what is the relation among those standards which are supposed to be not binding at law in principle and contract clauses. And what about the interpretation of clauses? I remain still a little bit, how to say, not sure regarding to this, because there is a big problem of transparency on these codes of conduct, because in some cases they've been adopted by international organizations, and you showed us, and I hope that we will have the printed papers later to study better. But in most other cases, they are just adopted by large companies all over in the world. And there was a famous scholar in administrative law in Italy in the 50s and 60s, which was Professor Massimo Severo Giannini, and he said, certainty is a typical function of public. Now, are we going through a road that gives to private bodies the responsibility to assure certainty? And in this case, which sort of guarantee we have to check those? Because of course there is the problem of the contractual relation among producers and suppliers. You were speaking about farmers in Mexico and so on. But at the beginning, there is the other trouble on how to adopt rules that impact on the daily life of the consumer with the characteristic of the product, and of course in the life of producers. This is the big question. I have not answers, I have only doubts, but I am very, very grateful to you for your, rich exposition on these points, and I will read it with great pleasure. And now we have Professor Ingeborg Schwenzer, and she is speaking on compliance in the global food system, and on a topic which it is the central topic of this day, assessing conformity and addressing breaches. Conformity to what and breaches of what? Thank you very much.
Let me first thank the University of Pavia for having this pleasure and honor to be able to speak at this conference. And most of all, I wanted to thank my dear colleague, Professor Alfredo Ferrante, for having organized this conference and also our CISG AC meeting here in Pavia, which is really a memorable event. So I will talk about CISG and ESG compliance in global agri-food sector, assessing conformity and addressing breaches. Thus, I will follow up on what my two colleagues said before me. I'll just give you a short overview of what I'm going to say after a very brief introduction, which can be very brief because my two colleagues already mentioned most of what I would have to say too. I will talk about the possibility to find sustainable values in the CISG itself. Then the CISG and external sustainable standards. And then I will dive into the CISG, I will dive into the non-conformity issue, the contextual significance of sustainable standards under Article 35 par 1. This is the first rule on conformity of the contract, and then the contextual significance of sustainable standards under Article 35(2) if the parties themselves have not agreed on certain standard. Then I will discuss the extent of liability, and what is not in my outline, I will also briefly come to the question of possible time limits and their problematic function when it comes to a recourse if the buyer is responsible for not having complied with sustainable standards. Let me begin with a story of my own academic development. It was about 20 years ago. I was already a member of the CISG Advisory Council when we had a meeting in Philadelphia, and for the first time, I think for the first time in the world, I voiced the idea that there might be ethical standards in CISG contracts. That was 20 years ago, actually. Nobody thought about that at that time. Actually, our chair at that time was the late Professor Peter Schlechtrim, and he was not at all amused about this idea. And he reminded me of the famous article by Milton Friedman of 1970, "The business of business is business, but not ethics." So that was probably the common idea at that time. Well, for me, fortunately, things have changed, radically changed since then. Today, everybody agrees that the question of sustainability is an economic issue. It's not just something ethical or so. It is economics. So we have a growing awareness of sustainability issues. Edgardo Munoz had talked about the unsustainable practices linked to global supply chains, corruption, environmental destruction, violation of international labor standards, human rights, child labor, forced labor, trafficking, and so forth. And he has also mentioned, and that is very important for the non-conformity issue under the CISG, that 90% of the major businesses do have specific programs nowadays dedicated to corporate social responsibility. They have codes of conduct. And I wanted to emphasize again what has been done by my two speakers before me, how important the ethical standards are, especially in food supply chains. It was only a couple of years ago, there was a class action in California against Nestle US and against Mars US. And the claim was that both companies had not sufficiently made clear on their websites that they couldn't entirely exclude that children were working on the farms where they were farming the cacao. So that was a food supply chain, and it could have been governed by the CISG, because the biggest chocolate grinder is in Switzerland. So probably Nestle and Mars US bought their chocolate from a seller in Switzerland. So that could have been an issue of non-conformity under a CISG contract. What has also been mentioned already, especially by my colleague Professor Munoz, is the fact that in more and more countries we do have a supply chains liability, starting with domestic regulations like in the US, in the UK, Australia, Canada, Brazil, France, Norway, the Netherlands, Germany, and I would say culminating in the CISG, the EU directive on due diligence for sustainability. And the EU directive goes further than many of the domestic regulations, insofar as the domestic regulations provide for fines, for example, if the company does not secure that there are no sustainability issues up the supply chain, whereas the CISG directive in the EU even provides for liability. That means the children that are harvesting the cacao in Cameroon, they can claim damages from the one who is doing business in the European Union. And that raises the question, if this person, if this company in the European Union or in another country with supply chains liability has to pay the fine or has to pay damages to the people concerned with a breach of the sustainability obligations, whether this company can have recourse to its own seller up the supply chain. And this is a question of non-conformity. So let me, before I turn to Article 35, let me first ask the question whether sustainable values can be found in the CISG itself. The question is whether the CISG embodies certain values. This question is rarely asked. The background is the CISG is a neutral commercial law. That is the very traditional approach, and it is clear why historically this was the case. The CISG was drafted in the 1970s and agreed upon in 1980 at a time where the sentence by Milton Friedman still was accepted, I would say, by most of the people. So if we look into the CISG, we hardly find any general principles that we could use to make a pledge for sustainability. The general principles we find in the CISG are party autonomy, pacta sunt servanda, equal treatment of the parties. This is very closely connected to the fact that under Article 4, Sentence 2a CISG, validity issues are excluded. Thus, controversial issues of public policy and certainly sustainability issues are such of public policies are excluded from the CISG. There is a certain possibility to find sustainable values in the CISG via its preamble that takes into account, or according to which it has different social, economic, and legal systems have to be taken into account, and the fact that the CISG should contribute to the removal of legal barriers in international trade and promote the development of international trade. This implies an awareness of international differences, but it is rather vague. Certainly, it might, if at all, serve as a guideline for interpretation of the CISG, but not for setting up obligations between the parties. So the CISG and external sustainable standards. There are some colleagues, especially a colleague from New Zealand, Petra Butler, that have tried to bring external ethical values into the CISG, and their starting point has been Article 7.1 CISG, a rule for the interpretation of the CISG. Article 7.1 addresses the international character of the convention and the need to promote uniformity in its application and the observance of good faith in international trade. The question is, can we derive anything from the international character of the CISG? Can we assume that this implies the application of general international public law, human rights? I'm very doubtful about this approach. The CISG regulates the relation between private parties and not public international duties of states. The other vehicle could be good faith as a gateway for sustainable standards. Also, with this, I do have my doubts, because during the drafting of the CISG, the good faith principle was very much debated, and that is why it only made its entrance into Article 7.1 as a principle for interpretation of the CISG, of the convention, but not as a principle of interpretation for the parties' contract or for their behavior. Thus, I think that getting sustainable standard into the CISG is difficult, but we can derive sustainable standards from a contextual significance under Article under Article 35.1, where primarily we focus on the conformity of the goods. My colleague, Professor Munoz, has already elaborated about the codes of conduct that most big companies nowadays have So the first approach would be that ESG standards come into the contract by the explicit agreement by the parties. It is today unanimously held that also non-physical features can lead to non-conformity under Article 35. This was still disputed about 10 to 20 years ago, but in the meantime, everybody agrees that also non-physical features, like, for example, that the goods were produced under inhumane conditions, or that, for example, they were not organically grown, that these features, although they are not physical features, can lead to a non-conformity of the goods. Thus, it is of utmost importance that we do have sustainability clauses today in international contracts, and especially also in food and agri contracts. That would be an express agreement under Article 35, paragraph 1 of the CISG that could lead to non-conformity if sustainable standards have not been complied with somewhere in the supply chain. However, Article 35, para 1 also applies if there is only an implied agreement. Whether there is an implied agreement, we have to find out by looking at the provision for contract interpretation, and that is Article 8, para 2 and para 3. We ask ourselves how a reasonable person would have understood the words and the conduct of the other person, and thereby we look at all the circumstances of the contract for example, the common membership of the two parties to the UN Global Compact on Sustainable Development could be an indication that they impliedly agreed on ESG standards in their contract. Professor Munoz also already mentioned that impliedly the parties make also part of their contract international trade usages that are widely observed in the trade concerned, and there are many such international usages relating to ESG standards, for example, the Kimberley Process Scheme relating to blood diamonds, or global standards in many industries, private initiatives, and Professor Munoz had especially mentioned the EU Code of Conduct on responsible food business and marketing practices that may nowadays be regarded as an international trade usage according to Article 9, para 2, and thus be made part of a contract under Article 35(1). That means the agreement of the parties. What happens if we do not have an agreement, be it express or implied, under Article 35(1) of the CISG? Then we have to turn to Article 35(2) of the CISG. This also applies if the parties did not come to an agreement, for example, because they have different codes of conduct. Under Article 35(2) CISG, it is important for the conformity of the goods whether they are fit for use. Be it under Article 35(2)b CISG, fitness for a particular purpose, for example, if the buyer is on-selling in specific markets, for example, in organic products, or if it is specifically mentioning fair trade to its own sub-buyers or the like. That could be a fitness for a particular purpose. If we cannot find a particular purpose, we turn to Article 35(2)(a) of the CISG, fitness for ordinary use. That means the goods must be usable in case of where the buyer is a reseller, a retailer, the goods must be marketable. And here I think of special importance is the increasing supply chain legislation. That means if a seller sells to a company in the EU now, it must be aware that the buyer in the EU, the buyer company in the EU, might be liable under the supply chain legislation in the EU, that means the CISG, if the goods have been produced in a manner that contravenes the sustainability issues in the supply chain legislation. So this seems to me very clear, and today I think having regard to the huge discussion around the world about supply chain legislation, it should not be possible for any seller to say, oh, I didn't know anything about this public law requirement in the European Union. Let's come to the extent of liability if we find that the goods have been non-conforming. Professor Munoz already mentioned that the CISG is based on strict liability, unlike former, I might say, or still many civil law countries that are based on a fault system, that damages are only possible if the seller was at fault. Under Article 79 of the CISG, the seller is not only liable for its own conduct, the seller is strictly liable for the whole supply chain. That means if the contract provides for ESG standards and the goods do not comply with these standards, the seller is liable no matter whether itself knew or even could have known that the goods were, for example, manufactured or harvested by breaching ESG standards. However, under Article 6 of the CISG, the parties are free to derogate from the principle of strict liability. Professor Munoz already mentioned that they can do this by clausing requiring best efforts only. So the question is, what are the consequences of such clauses regarding the liability of the seller? Well, if the parties agree on a best efforts clause, there is no alteration of Article 35, para 1 or para 2 CISG. Still, even if the parties say the seller has to provide best efforts that the goods comply with ESG standards, it is still the ESG standard that defines the conformity under Article 35. The consequence of a best efforts clause is with regard to the strict liability principle under Article 79 1 of the CISG. The seller who has complied or who has used best efforts for the goods to comply with ESG standards might argue that there is an impediment beyond its control, so it's not liable under Article 79.1, the strict liability principles, if the goods do not comply with the ESG standards. What is important, however, in this context is Article 79, para 5 CISG, namely, if the seller may invoke an impediment under Article 79.1, it is not liable in damages, but according to Article 79, para 5 of the CISG, the buyer keeps all remedies except for damages. That means it may avoid the contract and thus ask the purchase price back. It may ask for a price reduction, and the only point is that it may not claim damages, but it is not without a remedy. My last point are possible time limits. The statutes of limitation in supply chain liability acts often have a longer limitation period than 2 years. The CISG, for example, provides for a limitation period of 5 years. That means the buyer of the non-conforming product might be liable for 5 years towards the children or towards the persons affected by environmental issues in the country of harvesting. And there are two problems now. The first problem is Article 39, para 2 of the CISG, that is internal to the CISG. According to Article 39.1, the buyer loses all rights if it does not give timely notice of non-conformity. Notice within a reasonable time after it has known or should have known about the non-conformity of the goods. Article 39, para 2 then provides that in any event the buyer loses the right to rely on a lack of conformity if it has not given notice of the non-conformity within 2 years after the goods were actually handed over to the buyer. Thus, we might have, and probably will have, the situation that the buyer is liable for a much longer period, for 5 years, under the CS3D, and under the CISG, we have this 2-year cut-off period. There is an exception in Article 39.2, and that is unless this time limit, the 2 years, is inconsistent with the contractual period of guarantee. In my view, it would be possible to find an implied agreement between the parties that the seller guarantees that the goods comply with ESG standards if, for example, the seller delivers the goods to an EU buyer who is liable for much longer. But this does not solve the whole problem, because we do have this cutoff period in Article 39, para 2 of the CISG, but this is not a limitation period. The CISG is not concerned with limitation We have a sister convention to the CISG, the Limitation Convention, but this has not as many member states as the CISG itself. The CISG has now 97. The Limitation Convention has only some 30s or so member states. Thus, in most cases, we do not have a uniform limitation period. The limitation period for Limitation Convention provides for a 4-year limitation period, but we must turn to domestic laws, to domestic civil codes, domestic statutes on limitation. And there we have a huge difference between civil law countries and common law countries. In civil law countries, it is distinguished between a so-called, also in Italy, I suppose, between a so-called peius, that means non-conformity of the goods, and a so-called aliud, which leads to a claim for non-performance. And the limitation periods differ considerably. They are very, very short for non-conformity in civil law jurisdiction. In some Latin American countries, starting from 30 days. In Europe now, uniformly 2 years. That has come in with the Consumer Sales Directive. Whereas the limitation periods for aliud are much longer, sometimes up to 30 years. So if we are, or if a civil law legal system applies subsidiarily to the contract, then we might have also the problem that we have a very short limitation period that is much shorter than the 5-year limitation period under the CS3D. Different in common law legal systems. In common law legal systems, we have much longer limitation periods, and we do not have the distinction between non-conformity and non-delivery. They are between, the limitation periods are between 4 and 5 years for all contractual claims. Let me come to my conclusion. It is doubtful, as I mentioned, whether the CISG in itself promotes sustainability in global supply chains. However, we do have the contextual significance of sustainability standards that can be read into Article 35, be it by an agreement by the parties under Article 35, Para 1, or with regard to fitness for use under Article 35(2). Problems arise especially with time limits. These problems will have to be discussed in the future. Thank you very much for your attention.
Many thanks, and Professor Schwenzer has taken us hand by hand within all the difficulties of applying and interpreting contracts under private law in relation to this sort of increasing supply chain legislation, what I noticed. And there is one, and of course, this includes a lot of questions regarding time limits, limitation of action, differences among different countries, and which right of action as the final consumer. And this induces me to consider another thing which is emerging, the non-apparent, the non-material qualities of the good. Because we are speaking now about sustainability, what has been done along the chain. You made that interesting example of children which were not paid enough and who is responsible to pay the damages. But there is no effect on the final coffee that the consumer drinks. So is the consumer entitled to actions also with reference to non-material qualities of the good? And on the other side, the question which I must admit is still not very clear under European legislation. What we intend for sustainability? Because a case that you were mentioning, it was of course a case of social sustainability. It was not a case of environmental sustainability. And usually when we use the word sustainability, we all think to environment, while there is a lot of other points to consider. And so still what remains to understand, it is another of the long series of questions that we are getting today, is what is the content of the contractual obligation of the single parties along this very complex chain. You mentioned that the seller must be considered liable for all what happened in advance. But is the seller able to know? And what is the value that the seller may give to a formal declaration which is given to him? Or, because we were speaking about conformity and addressing, assessing conformity, we were discussing before the conference on these new regulations, new European regulation regarding the non-use of some nicotinoids. Suppose that there is a declaration from a border of control of a very far country assessing that it was not used. And later on, sometime after, within the limitation deadline, it appears that in fact it was not true. Who will be responsible? May still we maintain that the seller, the final seller, is responsible, even if was not in condition to get this information.
Consumer probably would not have any rights if the goods were produced under inhumane conditions of child labor. What is decisive and what I have been discussing is the relationship between the buyer and the seller under a CISG contract. And there it is relevant, first, if the seller is responsible, for example, under any supply chain legislation, it will have a loss. And he wants to have damages for this loss. If it will be fined, or if for example, people from Cameroon will come and ask for damages, then it has a loss, and he wants to have damages for this loss. Or he wants to avoid the contract because he cannot market the goods in Europe. If they do not comply with the CS3D directive, then he cannot market the goods, and that's a loss. And also, if we don't have such a case, it is an economic loss if a seller, for example, take all these cases we had with Nike and other producers of goods that had a loss of reputation, which is a real economic loss, and they want to have damages for this loss from their seller. So, and the other question was the one that initially Professor Munoz addressed, namely and that I took up, that the parties can provide for a best efforts clause. And then there is indeed no liability for damages, but still the buyer has the possibility to avoid the contract and get the purchase price back, or to have a price reduction, so it is not left without any remedies. Yeah.
going back for a minute, only for a minute, to the consumer position. What about green claims? Because we have a lot of discussion in European legislation nowadays, especially with reference to food, on the so-called green claims. A seller who says, my chocolate has been produced respecting the rights of the minors, and so on and so on. In that case, the consumer has nothing to do with the material quality of the good, but with the immaterial quality. So the consumer is entitled to some action. I don't know exactly which sort of action. We are speaking a lot. It has been introduced in Italy, as I imagine you know, some years ago, the so-called collective or class action, which were not known in the Italian experience. They have been taken from the common law experience. And this may be one of the possible answers, but in any case, it is a lot of things, and I don't know if our chairman will give us all this time. So thank you, everybody, for the patience to listen. And I think we have a quarter of an hour, or not more than a quarter, not more than 20 minutes, and we will be here again. Thank you very much.
Okay, let's get started. First of all, many thanks in advance for your attention. Many thanks to all the organizers of this conference, and particularly to Alfredo, of course. Alfredo is a dear friend and colleague since 2011, when we first met at a conference in Montreal. In Toronto, not in Montreal, apologies. So many thanks for choosing me as a chair. Well, actually, I was supposed to chair a panel tomorrow, and I am just replacing Timo Vinikainen, who unfortunately cannot be in attendance. Now, our panel concerns contract law issues, and we have as speakers Ulrich Schrotter, who will talk about contract law issues in international sales of foodstuff, insights from the CISG case law, and then we have Jean-Sébastien Borghetti, who will talk about agri-food products, contracts, and new challenges under the French perspective. Jesi Matamer, by contrast, is not in attendance. Well, just a few thoughts before we start. Of course, Vinikainen would have provided different insights. I am fundamentally an international lawyer and EU lawyer. So what comes to my mind, based on what has been said thus far, is that there are many intersections between so-called public and private international law. Not that I subscribe to the distinction, because I also think that it is impossible to divide the two, or neatly, or definitely to divide the two areas. But let us rely on this distinction for the sake of conveniency. Now, for instance, what comes to my mind is, of course, private international law is a matter of international economic law, mostly, and here it intersects with the environment and so sustainable development. What is the impact of CBAMs, carbon border adjustment mechanisms, on contracts of sale of goods concluded under the convention? Seems to me that this is an unexplored subject. And then there are intersections also with areas outside international economic law and the environment. We mentioned human rights, but for instance, we have not only the international law of peace, but also the international law of war. The EU rebelli ac pacis, and so we see what's happening in Ukraine. Of course, war in principle suspends contracts between the parties in different countries, and here we have an impact on export of cereals. So just a few ideas for possible discussion, and I will leave the floor first to, to Ulrich on contract law issues, so the cases in international sale of foodstuff, insights from the CISG case law. Ulrich, please.
The light is on, wonderful. And with that, I'm happy to start with my presentation, with the catchword presentation being a subtle hint to the technical gentleman in the back of the room. Could I have my presentation? Wonderful. Yes, ladies and gentlemen, it's a great pleasure to be here, and thanks, of course, to Alfredo, who has just left. I'm not sure that I should take that as an indication he doesn't want to listen to my presentation, but he has hosted us very friendly and efficiently for the past days. My presentation today has the title Contract Law Issues in International Sales of Foodstuff, Insights from CISG Case Law. And the idea behind this research project that I conducted was to investigate whether the CISG, which applies to all kinds of goods, has been and is being applied differently when it comes to the sale of foodstuff, of food items across the borders. And if you think about it, quite a number of well-known CISG decisions over time have involved food. Strangely, this is in particular so when it comes to a decision by the German Supreme Court, the Bundesgerichtshof, the New Zealand mussels case, the milk powder case, the frozen pork case, and most recently, the ground maize case. The Bundesgerichtshof could almost be referred to as a Supreme Food Court, I guess. And the same is similar for courts in other countries. Against this background, I have asked myself whether the fact that food is sold has influenced the convention's application, and whether there is something like an industry-specific or area-specific application of the CISG. In order to find out, I have, with the assistance of my staff at the University of Basel, read those court decisions and arbitral awards in the CISG online database that deal with food or beverages, in order to identify any contract law issues that appear to be particular to the practice of international food sales. Today I will present some of the issues that I found, if you will, an insight into the insights. Other issues and many details will be in my written paper. If we start with some numbers, we see that a significant share of CISG cases decided by courts and arbitral tribunals in the past have concerned food or beverages. On this slide, that's numbers 1 to 7, 9 and 11. Number 0 in the statistics are live animals, which, as we know, are often also sold eventually for food purposes, but I have not treated them as food because they're still alive. And if you look at those numbers, then you see that overall those contracts made up together about 14% of the entire litigated CISG contracts, with the sale of vegetables and fruit being the largest category, with very close to 5% of the sales. I saw some significant overlaps with numbers we saw earlier when it came, I think, in Edgardo's presentation to the numbers of general food sales among the GPD of some countries. It is important to note that these contracts for food size are very often of a small or medium size, which may be so because foodstuff is often perishable, so that buyers may prefer to buy it fresh in smaller batches. Larger contracts that also occur to a certain extent primarily exist in form of long-term contracts. As, for example, in case of one contract concluded for a period of 20 years between a South Korean state-owned entity and a foreign seller, we don't know from which country, which called for a minimum delivery of 1 million tons of foodstuff per year. Obviously, this was an extreme contract, which apparently had been concluded or initiated by the South Korean government in order to prepare for possible food shortages within the country. Most other contracts, even the larger ones, are smaller than this one. Some food or beverage sales are different from what common experience might suggest. For example, a contract for the sale of vodka concluded between a Russian and a Dutch party, in which it was the Dutch side who manufactured the vodka and delivered it to Russia, and not the other way around. Other food transactions are probably more predictable, like one involving a Luxembourg meat trader who bought from an Australian seller, yes, kangaroo meat. As far as contract law issues governed by CISG are concerned, the sale of foodstuff is in many respects not different from other sales transactions. Many CISG provisions have therefore been applied to food sales in a by and large similar manner as to contracts about other types of goods. This has been true, for example, for the Convention's rules on contract formation, on the obligations of buyers, and at least generally also for the parties' remedies. By contrast, transactions over foodstuff have shown particularities, if you will, with the conformity of these goods, their inspection by the buyer under the convention, and notices of non-conformity to be given by the buyer to the seller were concerned. I will therefore concentrate on those cases. In doing so, I will not address them in a CSG provision by CSG provision manner, but I will touch upon 4 general pertinent topics that I have identified that are here on this slide under number 3A to D. First, the perishable nature of some foodstuff traded and the consequences for the CSG's application. The contractual nonconformity of foodstuff under the convention and the role of public health. The influence of divergent local foodstuff regulations, and finally the packaging of foodstuff and its relevance in CSG case law. Let me commence with the perishable nature of foodstuff. Of course, no foodstuff lasts forever, so that all food items are perishable to some degree. However, food that stays edible for a significant time and in food sector parlance therefore has a long shelf life, for example, grain, sugar, or canned food, are not the type of perishable I'm talking about today. In CSG case law, discussions about perishable foodstuff has mostly concerned the sale of fresh meat or fish, of vegetables, or of fruit. Nobody described the perishability issue better than an Australian judge when deciding a CSG case concerning South Australian cherries that had been delivered to supermarkets in Singapore and Hong Kong. He stated in his decision, and I quote, "Cherries need to be picked quickly once they mature. Once picked, they immediately start to die. Hence the industry emphasis on trying to preserve their quality and life for as long as possible through a process of refrigeration called the cool chain, which aims to keep the cherries at a constant temperature between 0 and 1 degree Celsius. Any break in the cool chain can have a significant adverse effect on the quality of the cherries," end of quote. Not surprisingly, a significant number of foodstuff-related CSG decisions deal with cool chains and the question whether and when they were interrupted. If perishable food goods have not retained their quality when arriving at the buyer's place, it is often a matter of dispute at what point in time their quality fell below the conformity threshold. As is well known, and you see it here on the screen, Article 36, paragraph 1 of the CISG provides that the seller is liable for any lack of conformity which exists at the time when the risk passes to the buyer. In sales of perishable foodstuff, Article 36 of the CISG has played a more important role than for any other type of goods. Frequently, the delivery terms agreed between the parties, notably Incoterms, become relevant in determining when the risk passes and which party therefore bears the consequences of the goods having deteriorated during the part of the contract before that moment or during the part of the transport after that moment. In practice, this leads on often exact temperature records being kept by the respective carrier, and those records are then often relied upon as evidence in court proceedings and in arbitration. When goods sold are perishable, they are in practice sometimes inspected at various times during a sales convention's execution, before shipment, when the goods are loaded onto the vessel, when they are unloaded at the port of destination, and or by the customs authorities or health authorities in the country of destination. Such inspections can have various reasons. Health and food regulations in the seller's or the buyer's country. Sometimes you find inspection clauses in CSG contracts that not only require the buyer to inspect, but sometimes also the seller to inspect before delivering and informing the buyer about the outcome of the inspection. Or just self-interest for a contracting party trying to be informed and possibly to preserve evidence about what it found. Judging by CSG case law, it is not always clear how such inspections relate to the buyer's duty to inspect the goods under Article 38 of the CSG, and whether such inspections influence each other, 38 inspections and others. Under Article 38, paragraph 1, case law has held, in any case, that perishable goods need to be inspected soon or in a very short period of time. Interestingly, Dutch and Spanish courts have repeatedly ruled that the fact that perishable foodstuff is frozen does not make it non-perishable, which I believe may technically be true, although it seems to me that the period for inspection could reasonably be longer if the perishable food is frozen and it is not, say, lettuce or something that deteriorates quickly. The second general topic I want to address are the interactions between contractual nonconformity of foodstuff on the one hand and possible risks for public health on the other hand. This interaction is almost unique to the food trade and different from the trade in many other types of goods. Similar situations do exist if it's medical goods, but in many other stuffs, you don't have that. If a buyer receives, for example, say a delivery of steel or of an industrial machine that turn out to be defective, the consequences are essentially a matter between him and the CISG seller, who may or may not be liable under the convention for the defect. By contract, a deficiency in delivered foodstuff may in addition raise public health concerns, which in turn can trigger legal and factual consequences. Legal consequences can consist of the customs or health authorities in the buyer's country, sometimes also in the seller's country, prohibiting the sale of the foodstuff, seizing and possibly destroying the goods, and ordering a recall of goods that have already been distributed. It is important to note that such consequences often extend beyond the limits of the particular contract, because one dangerous or supposedly dangerous food delivery under one contract may lead to the marketing of all goods of the same type being prohibited in a particular jurisdiction. Deliveries under CISG contracts may therefore, and often are, caught by public law prohibitions that were introduced in reaction to an entirely unrelated contract involving other parties. Factual consequences, on the other hand, are typically consumer reactions or market reactions, because health risks are very carefully watched by the public. Even where public authorities do not intervene, the mere rumor that possible health risk may exist in a particular type of food may put entire categories of foodstuff under suspicion so that the CISG buyer can no longer resell them. Although the CISG's provision on contractual conformity and on the buyer's remedies were not specifically designed to deal with the effects of food safety prohibitions and of market reactions on the performance of sales transactions, the Convention's provision must and generally also can operate well in the food sector. Sometimes the parties themselves refer to food regulations in their contract or therein allocate the consequences of possible interventions of health authorities or of necessary recalls. If the parties have not done this, the courts have had to solve what role public health regulations and government actions play in the context of CISG provisions. By and large, most CISG decisions in this area have been very fact-specific. Today I can only mention some examples. Many examples from CISG case law with public health concerns involve the sale of meat. And after having done my research for this presentation, I'm seriously considering to become a vegetarian. An incident that had broad effects was the dioxin scandal in Belgium in 1999, after animal feed had been contaminated by dioxin, affecting international sales of Belgian pork, Belgian beef, and Belgian chicken meat. Quite a number of CISG cases have dealt with it, including the Bundesgerichtshof's famous frozen pork case, which found that the mere suspicion that certain meat batches contain dioxin can suffice for purposes of Article 35 because the public fear of a resulting health risk may render the meat unsaleable. According to the Bundesgerichtshof, the lack of conformity in the sense of Article 36, paragraph 1, that's the time when the nonconformity has to exist, are therefore the facts which are suspected. For example, the contamination of all pigs slaughtered in Belgium during a particular period of time, and not the suspicion itself, which may only have arisen after that time. This is a possible, but certainly not the only possible interpretation of Article 36, paragraph 1, and it affects extremely what the buyer has to prove in a court of law. Another example on point was the CISG sale in 1993 of a dead horse from Canada to France, where its meat was resold by various specialized horse butchers in Paris, resulting in an epidemic that infected over 500 customers. The courts concluded that the Canadian horse delivery had been non-conforming under Article 35, paragraph 1 of the CISG because its meat was unfit for human consumption. And the findings of the French health authorities were accepted as evidence for that, although they did not relate to the contract proper. They related to the health authorities, but the court accepted it nevertheless as being a sufficient indication of nonconformity. Horse meat, again, became a problem 20 years later, although in a different way. This time, a French company had sold supposedly beef-based meat preparations to an Italian manufacturer of pasta sauces. Sometime later, the Italian health authorities discovered that the pasta sauce in fact contained horse meat, leading to a government ban of all products and a recall of those already sold. So if about 10 years ago you bought Italian pasta sauce that tasted, well, a little different, now you know the possible reason for that. This case has already been to the French Cour de Cassation, the highest court in France, twice, has clarified that the CISG seller, in this case the French seller who had bought the goods from a Dutch supplier, cannot rely on Article 79, paragraph 1 in order to escape its liability, even if his supplier has had fraudulently delivered horse meat instead of beets, because the procurement of supplies is not beyond the seller's control in the sense of this provision, even if he himself was defrauded. That is very different from many domestic laws that rely on notions of fault. So the CISG is stricter here on the seller. One type of foodstuff where health risks are particularly carefully scrutinized in practice is milk powder, notably milk powder to be used as baby food. CISG contracts over milk powder often contain very detailed specifications not only about the eventual product, but also about the production process to be followed by the manufacturer and then seller. In addition, milk powder is often the object of so-called double-barrel testing requirements under both health regulations and contract clauses, with the powder furthermore having to be quarantined at the manufacturer's facilities while its quality is being tested. That means it cannot be delivered at all before the testing has been completed. However, in spite of those preparations and prevention efforts, milk powder can still turn out to be non-conforming in practice. A clear case in this regard from CISG case law concerned milk powder delivered to the Dutch Antilles, which turned out to have a sour taste, like old butter, and furthermore contained local insects called guru-guru. This is a guru-guru. In other insect cases, well, under milk powder cases, it was primarily salmonella bacteria or other bacteria which were detected in the powder, often only after the infants had gotten sick. When goods of this type then have to be recalled, this often damages the entire brand and the reputation of the brand owner, raising complex questions when it comes to the calculation of the recoverable loss, which may or may not have to be borne by the seller. Under the CISG, the seller does not escape liability, as courts have held, even if the procedure in his milk powder factory were flawless in terms of hygiene and their implementation perfect, and if the contamination of the milk powder was found by experts hired to be, and I quote from a case of a random phenomenon, highly unlikely, totally unforeseeable, and against which nothing can provide protection. End of quote. Nevertheless, the seller was found to be liable because the manufacturing process is under and not beyond the seller's control in the sense of Article 79, paragraph 1. Let me turn next to the influence of divergent local foodstuff regulations. What I mean is foodstuff regulations that exist in one country or maybe one region of one country, but not in others. In a number of cases under the Convention, there was no need to consider regulations in order to know that the foodstuff delivered was non-conforming, because in those cases it was plainly obvious to anyone. In CISG case law, this was, for example, so where a Spanish seller had sold supposedly high-quality canned mushroom to a Finnish buyer, and the buyer's customers found some cans to contain little stones, cigarette butts, and even plastic gloves. Or a case where another Spanish seller had sold boneless beef to a French buyer who discovered plastic waste inside the packages. Just a random choice, had nothing to do with Spanish sellers in all the times. And here's a point to prove. In an early case decided by a Dutch court, an Italian seller had supplied the Dutch buyer with mozzarella cheese, which turns out to contain maggots and worms. One is slightly concerned to read in that judgment that a large part of the mozzarella was nevertheless used by the buyer, who therefore only claimed a partial reduction in price under Article 50 of the CISG. And this buyer apparently took the general duty to mitigate loss to an entirely new level, and one doesn't know how that precisely happened. However, often an alleged nonconformity of the foodstuff does not arise from the state of the goods when viewed in isolation, as in the cases that I have just summarized, but the nonconformity potentially only applies from the goods non-compliance with local food law. The crucial question, whether the food delivered under a CISG contract have to be in conformity with local standards that exists in the buyer's country, but not in the seller's country, was first decided by the German Supreme Court in the famous New Zealand mussels case involving the sale of New Zealand mussels like these ones, not exactly these ones, by a Swiss seller to a German buyer. Applying Article 35, paragraph 2 of the CISG, the German Supreme Court ruled that a seller can generally not be expected to comply with public law provisions in the buyer's country or another country where the goods will be used, although there are certain exceptions to that rule. The CISG Advisory Council has adopted a similar, although somewhat more flexible approach in its opinion number 19 on standards and conformity of the goods under Article 35 per CISG. In case law under the CISG, courts have dealt with various types of local standards or public law provisions, in the words of the BGH, in buyers' countries, including technical standards for machines, roadworthiness standards for trucks, or during and after the COVID crisis, in quite a number of cases, standard for protective face masks, which also varied a lot between jurisdictions. The majority of cases, however, statistically have dealt with local food law and have demonstrated that food law creates extra challenges in this context. First, the requirements that certain types of food law have to fulfill under food laws, foodstuff has to fulfill under certain food laws or health regulation, very often differ from country to country, because the fitness of certain food types for human consumption and possible health risks are neither viewed nor regulated identically around the world. At the same time, existing food regulations are typically strictly enforced by the local authorities, with non-compliant food being seized and destroyed. Compliance with local food law therefore amounts, in essence, to an all-or-nothing threshold for the seller and the buyer. The second reason is that local food law standards are often less clearly regulated than technical standards, and therefore particularly difficult to foresee. Such was the situation in the New Zealand mussels case, where the local German authorities had criticized, not even stopped, but only criticized an allegedly excessive amount of cadmium, a toxic metal, in the mussels. There was no German law at all on admissible cadmium in fish or mussels, but the local authorities had applied the German provisions on cadmium in meat by analogy, and this administrative practice, furthermore, was not done uniformly throughout the country, but varied from parts of Germany to other parts of Germany. Third, the standards for foodstuff often evolve over time and are frequently changed on very short notice when potential health risks of certain foods have been discovered or are suspected. In such cases, the decisive time for conformity under Article 36, here it is again, it becomes important also in this scenario. In a recent case, a Dutch seller had sold Brazilian meat to a Belgian buyer, and the meat was to be shipped by the Brazilian slaughterhouse directly to the buyer. Shortly before the vessel carrying the meat across the Atlantic Ocean arrived at the port of Rotterdam, the EU prohibited any import of meat from this Brazilian slaughterhouse into the EU. A Dutch court found that the parties had agreed on the delivery term FOB Santos Brazil in their contract, and that the import prohibition had not yet existed when the meat had been loaded onto the vessel in the Brazilian port of Santos. Accordingly, the goods had been conforming at the moment of time mentioned in Article 36, paragraph 1 of the CISG. This is a logical application of Incoterms in conjunction with Article 36 of the CISG, but it's not necessarily convincing that the case was decided in that way. It's essentially just a matter of distribution of risk on the time scale, if you will. In this particular case, in addition, the Belgian buyer would certainly have lost the case because, in this case, the Belgian buyer lost, although the Dutch seller would have lost if the point in time would have been different, because those EU regulations did exist in the seller's and in the buyer's country. So the seller does not have to comply with buyer country regulations, was not a problem in this particular scenario. But the FOB clause meant that the seller was not liable. Finally, and maybe somewhat surprisingly, the packaging of foodstuff plays a very important role in CSG case law. When thinking about packaging, I am instinctively reminded of Article 35, paragraph 2, subparagraph D, where the convention provides that the goods do not conform with the contract unless they are contained or packaged in the manner usual for such goods, or where there is no such manner, in a manner adequate to preserve and protect the goods. This provision is generally read as aiming at the goods' preservation and protection during their transport to the buyer, and it has sometimes been applied in this way to foodstuff. However, packaging of foodstuff plays a much more prominent role elsewhere, namely where the merchantability of goods, its resaleability to the buyer's customers, is concerned. In contrast to the general advice that we sometimes say, don't judge a book by its cover, foodstuff is typically judged by its packaging by the customers, and this makes the correct packaging a very important factor when the conformity of food delivered under a CSG contract is assessed under Articles 35.1, 35.2a, or 35.2b of the CSG. In case law, this has often been so because of labeling requirements in the law of the buyer's country. In particular, there are an entire range of EU directives that harmonize provisions of food information to consumers on product labels, or more specifically, for example, on the way that the foodstuff's treatment with radiation has to be displayed on the labels if food has been radiated. When the goods packaging fails to display such information, this alone can render the goods non-conforming under the CSG. And it does not matter in these cases whether the goods themselves are actually harmful to health or not, because the incorrect labeling suffices. Obviously, buyers also may find it easier to prove labeling defects because they do not always have to have the goods tested for its ingredients in a laboratory or a similar service providers. Sometimes labeling errors have resulted in goods already being stopped by customs authorities and not being allowed into the buyer's country. In other cases, it was the type of packaging that rendered goods non-conforming, as in a case in which French beef was not individually wrapped in accordance with EU rules, resulting in a Dutch buyer losing agricultural subsidies that he would have collected had the goods been packaged differently. The beef as such was flawless. One could assume that packaging requirements cause less difficulties when the parties have agreed on them in their contract, making them a case of Article 35, paragraph 1 of the CSG. But also here, difficulties may occur, which provides insights into practical challenges of the food sector and of the trade in food. Two examples have to suffice today. The first case concerned the purchase of 500,000 small bags of Haribo Goldbeeren, bought by a Dutch company for delivery and resale in West Africa. The gummy bears delivered did not bear the German word Goldbeeren, but the English word Gold Bears on the packaging, although the sweets inside were exactly the same, manufactured by the same factory. The buyer sued the seller for damages because the consumers in West Africa refused to buy Gold Bears, insisting that only the German labeled Gold Beeren were the real quality product, because they were afraid that they had been tricked by somebody trying to use wrong packaging. In this particular case, the court found that the goods were conforming under Article 35.1 and 35.2d because the buyer had not made the importance of the German name sufficiently clear to the seller, but they may have been different, may be different in other cases. The second case, and the last case that I have for you today, demonstrates that sometimes the correct packaging is defined somewhat differently by the parties. In a sale of oranges from a South African seller to a French buyer, the contract required the bags and boxes in which the oranges were packed to always declare them to be Category 1 oranges, but at the same time the contract provided that the seller was free to fill Category 1 or Category 2 oranges into the bags and boxes so labeled. The contract written in French stated in the field qualité, here comes my broken French, marqué Catégorie 1 sur le sac et le carton, mais tu peux jouer avec les catégories 1 ou 2. You can play with categories 1 or 2, but you always have to put Category 1 on the bags. This comes very close to a contractual agreement to defraud the eventual customers to whom the supposedly Category 1 oranges would be sold. It is therefore no surprise that the CSG buyer was not allowed to refuse payment when he found Category 2 oranges in some of the bags, because the South African seller claimed successfully in a French court that he had complied with the contract. He just had played with Categories 1 and 2. Let me briefly conclude. What contract law issues have particularly often arisen in international foodstuffs transactions under the CSG, and why? First, the perishable nature of some foodstuff makes the precise state of the goods at the moment described by Article 36, paragraph 1 of the CSG, the passing of risk moment, a much more important question than under most other food laws, most other contracts, sorry. And a buyer's claim very often stands or falls with his ability to prove that the foodstuff was already in a non-conforming state at that precise moment. In reaction, an entirely particular type of drafting of such contracts has developed by the parties frequently trying to contain the perishability risks by contractual requirements relating to an unbroken cool chain. In addition, the perishable nature of food influences the buyer's inspection duties under Article 38 of the CSG. Second, as contractually non-conforming goods can also be, or merely suspected to be, a public health risk, the CSG standards that have to operate in conjunction with actions taken by government authorities and with consumer or market reactions, very often in more than one country. And sometimes these third-party reactions are triggered by events entirely unrelated to the particular country, contract and transaction. The interpretation of CISG provisions, Article 35, Article 36, and 79, paragraph 1 of the CISG, has aimed at reasonably allocating such factors to the sphere of risk, either of the seller or of the buyer, but also here, the parties who are busy in that area of trade very often try to specify everything they can in their contract. Third, and in close relation to that issue, the role of divergent local foodstuff regulations may at first sight seem to be a mere variation of the general theme of local standards under the CISG's contractual conformity regime. But upon closer look at CISG case law, it has become clear that it causes much more intricate problems when food is concerned, given in particular the lower clarity and more frequent adjustment of such food safety regulations. And finally, don't underestimate the packaging of foodstuff, which plays and most likely will continue to play a very significant role for the goods conformity and their merchantability. Thank you very much for your attention.
Many thanks, Ulrich, for this insightful and exhaustive reflection on food market sustainability. I wonder if there are any cases on greenhouse gas emissions in the food market, but maybe we can collect and answer at the end because we are running short of time. This raises maybe this question, and if not, if we can apply by analogy this case law to possible cases involving greenhouse gas emissions. Maybe we can collect questions at the end. And now, many thanks, Ulrich, and now Jean-Sébastien. On agri-food products, contracts, and new challenges from the French perspective. Thank you very much.
Thank you. So I wish also to thank Professor Ferrante for his kind invitation to Pisa, although I'm not quite sure that being invited to be the last one to speak and the last one to stand between you and dinner is so very nice for me. But anyway, relationship between or interactions between food and the law are quite obvious, and as far as we can know, they have always existed. Food obviously is a very important aspect of human life, and so law has to do with it necessarily. And the interaction between food and law goes both ways. So food has an influence on the law, and law has an influence on food. So food has an influence on the law. There is a rather well-known example, which I think it's the right moment to cite now. It's the hungry judge effect. So you might have heard about that. There's some studies have been made which suggest that at the end of the day or at the end of the morning, when the judge gets hungry, he's less lenient than at the beginning of the day or at the beginning of the afternoon after he's had a nice breakfast or a nice lunch. So you're not going to be very lenient to me because you're now getting very hungry. So food can have an influence on the law, and of course the reverse is true also. So the law can have an influence on food. We all know that through, for example, religious legal systems. I mean, we know that in Islamic law, for example, there are some types of food which you're not allowed to eat. But if I may give you another example, more closely connected to my country, France, you know that we're famous in France for having different kinds of cheese. And why is it so? Well, there's actually a legal reason to that. Well, before we had electricity or pasteurization, a great issue for farmers was to keep milk because, goats and cattle, cows, they produce a lot of milk, and you can't drink it at once in summer, so you've got to keep it one way or another. But the thing is, when you've got no pasteurization, the best way to keep it is to do butter. But butter itself cannot be kept unless you salt it, so you've got to salt your butter. The problem is, in France, we had a specific tax on butter, on salt, which was called the gabelle. We've always been very good at taxes. I think we invented VAT, and we also invented that tax there. And so salt was very expensive, and therefore it was too expensive to make salted butter. So peasants, instead of making butter, made cheese, because to make cheese you need salt, but you don't need as much salt as you need to do butter. And so that's the reason why each village in France had its own cheese, and this has remained to this day, although we abandoned that tax quite some time ago, but we've kept the cheese. And interestingly, there's one region in France, Brittany, which has no typical type of cheese, but which is famous for its salted butter, and that's Brittany, which is a region where you had no tax on salt for various historical reasons. So this, I think, is a good example of how law and food interact. But while this interaction is obvious at a general level, it's not so obvious if you look at contract law, which is what we're interested in today. And the reason why it is so is that contract law, at least as it is understood in civil law systems, is normally, I think in all Western legal systems, is, you could say, product neutral. So the rules on contracts do not depend on the precise subject matter of the contract. So you've got rules, of course, according to different types of contracts, lease and sales or whatever, but you don't have specific rules normally, at least in the civil code, on contracts for food or contracts for cars or contracts for mobile phones or whatever. There are a few exceptions to that. For example, you could find in many civil codes, you could find provisions which clearly only apply to food. For example, provisions that say that there are some products which you cannot buy before you've tasted them. You've got that in some old civil codes, so obviously it applies to some types of food. But generally speaking, contract law is neutral. And that is the rule, and that is also very understandable as far as food is concerned, because so you don't have that many cases about food. Well, you have cases between professionals. So in business-to-business contracts, you have cases about food. You've got very few cases about food in business-to-consumer contracts, B2C, just because the stakes are not high enough. I mean, contracts for food by consumers have usually very low value. So you might have legal issues, especially as far as liability is concerned, but you will it's very rare that you will have specific contract cases dealing with food in B2C contracts. And yet, food obviously is very important to us, but it's not only food, because behind food you have the whole agri-food industry, which is extremely important. And a very striking phenomenon, I think, in French law, and that's why probably it's interesting, that's why Alfredo asked me to talk about French law, is that the specificity and the importance of the agri-food industry has resulted recently in specific rules being developed for agri-food contracts. So initially, contract law is neutral, but this neutrality is being challenged as far as food products and the agri-food industry is concerned. And so it's interesting to see how this neutrality is being challenged. And I think there's mostly two ways. There's an obvious way in which agri-food products, contract law rules are being expressly adapted to agri-food products or the agri-food industry. And then there's a more subtle way in which those products or this industry will have an influence on contractual practice. So there are the actual rules which sometimes are adapted to the agri-food industry, and then you've got contractual practice, which is something more difficult to assess, but which is also very important. So if I start, and I'll try to be as short as possible, with agri-food products and contract law rules, a very striking thing in France is that specific rules have been applied in contract law specifically, which only apply in the context of food products or the agri-food industry. And you see that both in B2C contracts, so business-to-consumer contracts, and in B2B contracts, business-to-business. So in B2C contracts, you don't have that many rules. Those are mostly rules on information of consumers. And we have, for example, but now you've got that everywhere. We were kind of pioneers in France, but we've got consumer law rules on labels, for example. You've got now many types of labels about products, and so you can have contractual obligations to inform contractual partners about those labels. But that's not the most important. What is much more striking, I think, is the way in which agri-food products or the agri-food industry is influencing B2B contract rules. So we have, I think, we have in France, as probably in many countries, we have a big issue about the economic balance between, on the one hand, food producers, or rather peasants, and other actors in the food industry, which can be either industries or most often distributors. And typically we have an imbalance between, on the one hand, peasants who produce food, who have little economic power because they're small companies, and on the other hand, distributors, which are very large and have enormous economic power. And so they can yield, they can impose very low prices on peasants, and they can impose very harsh rules or very stringent contractual clauses. And this has been an issue for a very long time. Already at the beginning of the 20th century, we had a special rule which was developed only for the sale of fertilizers to peasants. So it was not between distributors and peasants, but between the industry and peasants. So that was 100 years ago. But since now about 20 or 30 years, the French legislator has decided to develop rules to specifically protect peasants against distributors, basically. So what is very interesting is that those rules have really been developed with this industry in mind. The idea was really to protect peasants against distributors. In practice, the rules have been drafted in more general terms. So those rules apply more generally between businesses. But the reason why we have these rules is that we want to protect peasants from distributors. And so in our commercial code, so not the civil code, but in our commercial code, we have a certain number of provisions which basically prohibit or impose certain clauses in contracts to protect peasants. So, for example, it is illegal, just to give you an example, it is illegal between businesses to obtain or attempt to obtain from the other party an advantage for which there is no consideration or which is manifestly disproportionate to the value of the consideration given. So it's a great restriction to freedom of contract. Normally, freedom of contract means you can have an imbalanced contract. It's not a problem. It might be a moral problem, an economic problem. It's not a legal problem. But here, the law tells you, no, you're not allowed to have a real disproportion in the contract. You're not allowed to apply to the other party discriminatory prices, for example, or payment periods, or things like that. So it goes very far. It is very illiberal in its philosophy, but it is intended to protect, well, first of all, to protect peasants against distributors. And this legislation has been developing for now 20 or 30 years and has actually been modified on several occasions because it doesn't really work, actually, because distributors probably have good lawyers and they always find ways around these rules. And so the rules keep changing, well, not radically, but they keep being amended to try and reinstate a better balance, a better legal balance between producers and, well, farmers and distributors. So we have basically specific contract rules which totally derogate from normal, you could say, freedom of contract, but which are really intended to protect peasants. And then the second way, I think, in which agri-food products influence contract law is more indirectly through, not directly through rules which derogate from common law, but through contractual practice. And so there always have been some specific, customs or usage which are specific to certain contracts in relation to food. For example, in France, it's well known that in the wine trade in Bordeaux, you have specific rules which apply, and that has been the case for centuries. And it's not what I'm interested in right now. I think there's something much more interesting and which connects to things that have already been said, and that's the due diligence duty. So we've already mentioned that European directive on due diligence, which was adopted this year and which will come into, well, which will be implemented in the near future. But in France, we have a statute on due diligence since 2017. So it was adopted in the wake of the famous Rana Plaza tragedy in Sri Lanka, I think it was in 2013. Anyway, France was the first country, as far as I know, to adopt rules on due diligence. And so we have two provisions in the French Commercial Code, again, which are, in comparison to what has been done afterwards in Germany or the Netherlands or now in Europe, is rather unsophisticated. We only have two comparatively short provisions. But it's nevertheless interesting, and basically what those provisions say is large companies must draft vigilance plans, as it is called, and so they must map out the risks in terms of human rights, environment, health, safety. So they must map out the risks of their activities, and especially the risks, well, of their activities, but including, of course, their subsidiaries in foreign countries and their subcontractors, because that's the whole point. How are you going to monitor the activities in other countries, developing countries? So you must map out the risks and say how you're going to try and face those risks and limit the risks or damage that can be caused. The sanction of this due diligence duty is mostly civil liability. So if a company doesn't abide with this obligation, it can be sued. In practice, I think it's going to be very difficult to make companies liable under these provisions for a number of reasons. First of all, because there are some private international aspects which haven't been taken into consideration by the French legislators, so we have a gap here. And also because proving causation very often between the fact that you breached the due diligence duty and damage that was ultimately caused will be very difficult. But it's not that important, because what is important is that now we have many non-governmental organizations which are bringing companies to court. And these cases take a long time because they are being fought bitterly. There are many disputes on procedural issues. So it's going to take a long time, and I don't think we're going to have many French companies paying damages for that. But it's not the main point. The main point is that NGOs are bringing cases against those companies, and so those companies have to do something. Well, first of all, the law says that they must have these plans, but they're also being forced by the companies to do something. And that's where it comes to contract, is that obviously the way, and that has already been said, but the way in which they're going to implement their obligations and their due diligence duty is obviously by imposing obligations on their partners in developing countries. And so these obligations, which are statutory obligations in France, are translating into contractual obligations imposed on other operators in the agri-food industry in other countries. And so it is the way in which we kind of export those requirements, which raises a certain number of questions. I'm aware that it's already very late, so I'm not going to talk about them anyway. Many of them have already been considered in the context of the CISG. The only thing, but that's obvious and everybody's aware of that, is that, of course, there's a risk that through these contracts, I mean, French companies today and European companies tomorrow will just shift the burden of that to their subcontractors in other countries, and they will basically wash their hands. So this is, of course, the risk. Okay, I have these new obligations. Well, I'm imposing per contract these new obligations to my, whatever Chinese or Indonesian subcontractors, and I have done what I had to do, and so don't bother me now. Of course, it's a bit more complicated than that, and NGOs are there also to try and avoid that such things happen. But contracts in that context are both very efficient at, you could say, propagating these obligations, but at the same time, of course, they carry the risk that companies will shift the burden to, to other actors in the food chain. Thank you very much for your attention.
Many thanks, Jean-Sébastien, for this very insightful presentation, which, of course, contributes to shedding light on the sustainability of the food market, because not only human rights, health and safety, but also the situation of peasants is by definition a matter of sustainability in the light of the UN work and resolution on the issue and the Brundtland report. I would have the same question for you, if there are any cases on greenhouse gas emissions, but given that we are running very late, well, I would also love to open the floor to Q&As, but I think we're really beyond schedule, so either if you want to say really a couple of words, otherwise we can discuss over dinner later, up to you really. Enlighten. We don't open to Q&A. If you want to answer this question on both on cases, 2 words, or otherwise we can close and discuss later. Up to you.
Well, the answer is also going to be very short. No, there are no cases of that sort, and the reason is that typically when they have a problem, the buyers have a problem, they terminate the contract. They just don't go back to the seller, but that they litigate with the seller. There are none on the CSG I'm aware of.
Thank you, Jean-Sébastien. In France, any developments on cases on greenhouse gas emissions in the food industry? No. Not at all. Okay. Okay, thank you. Then we can conclude here and discuss the possible analogical application of these cases to greenhouse gas emissions. Many thanks. On that note, we can conclude. Apologies for not opening the floor to Q&As. Thanks for your attention.